The big idea of today's First for Disputes conference is to provide clients with a deep insight into hot current issues impacting contentious areas of work, but also crisis situations and major investigations. We brought the subjects together after extensive client feedback because we really wanted to cover those issues which we know really concern clients.
In our workshop today, we were looking at trade secrets and employee competition. Employers are going to be greatly helped in Europe by the EU Trade Secrets Directive, which is going to come up before the Parliament on the 28th of April. One of the most important things that that's going to introduce for employers is the ability for the first time to have internationally consistent employee documentation.
The main topic I've been talking about today is the implementation over the next few years of the EU Antitrust Damages Directive. It's an important piece of legislation which will harmonise the rules on competition damages claims around Europe. It'll have a big impact around the EU, in fact. It'll make changes to rules on things like disclosure and time limits and allocation of liability. So it's a thing that we all need to be aware of and work through over the next few years.
I've chosen to talk about the Unified Patents Court today because that and the Unitary Patent System are coming into effect next year, and patentees and prospective patentees need to know about it so they can review their licences and see how they will be affected by the new system, but also so that they can review their patent portfolio to see which of their patents they need to opt out.
The most important thing about terminating contracts is to have a strategy. You need to take account of not only the legal position, which may be very strong, but also the practical considerations, financial, operational, HR and reputational considerations, blend them all together and then decide whether or not to terminate. This is particularly important because we work with organisations from many different sectors, many came today, and the strategies will vary in the different contexts in which our clients operate.
So we've just spoken about developments in the area of anti-bribery, corruption and investigations, and this included potential widening of scope of the Bribery Act, the hot topic of whistleblowing and the formalising of whistleblowing arrangements, and the US-style deferred prosecution agreements that has just come in, which will enable companies that got themselves into difficulties to potentially self-report to the SFO.
Privilege is an incredibly important topic. It protects confidential communications between a lawyer and his client, and it often gives rise to a lot of misunderstandings, even amongst experienced practitioners. What we spoke about today hopefully provided clarity on the subject, as well as some practical tips on how to avoid some of the pitfalls.
Today I spoke about the proper drafting of arbitration clauses, and this is a very important subject. And the reason why it's so important is that if you get it wrong, it can really cost you. And it can cost you in terms of additional disputes that you may get because your clause is so unclear. It may also cost you in the sense that you don't even make it into arbitration at all and that you end up before the court where you didn't want to be in the first place.
Bringing people together today gives us an opportunity to explore the issues in greater depth, learn from the clients about what worries them about the issues being discussed, and so we can plan to do better in the future about covering those issues for them at other training events.
It's extremely important that we actually are able to discuss with our clients the various upcoming disputes and systems that they need to be aware of. Not because they'll necessarily be involved in a dispute immediately, but so that they can prepare for such things and hopefully avoid them.
A particular highlight for me was the session around the Unified Patent Court. My company has a lot of intellectual property. As a litigation lawyer I get involved in a number of IP related disputes, so it's really helpful to understand what the future is for patent infringement claims. So that was a really good session.
This morning's session on trade secrets and restricted covenants was particularly useful for me, given that I'm an employment lawyer. We've got a particular issue at the moment which I'm trying to resolve with an employee who's gone to a competitor, and we're trying to protect our trade secrets. So I got some great advice from Warren on that, and I found that fantastically useful.
It's good to mix with other in-house lawyers, understand their experiences, share problems, because it's too easy these days to just exchange emails or speak to people over the phone, so it's good to do things face to face once in a while.
We live in an increasingly contentious age. We're entering an era where our regulators in so many industries are so much more interventionist in terms of what they're investigating. And of course our laws on fraud and corruption are tightening up all the time. And increasingly our clients, whatever size, are turning to us because they want a better guide to help them through that maze.